Have you or someone you know been injured in a motorcycle accident? If so, I have some information to share with you today you'll want to hear. I've put together several of the most common questions I get when it comes to motorcycle injury cases. Let's get started. Hello, my name is Joe Benson. I'm an attorney with Alliance Legal Group. I am part of the litigation team whose sole purpose is to represent you and only you against the insurance company. You will always know that we are there for you. The common question I receive is, I wasn't wearing my helmet during the accident. Do I still have a case? Whether you were wearing your helmet has nothing to do with who is responsible for the accident. As long as you were found not at fault for the accident, then liability rests with the other driver. Wearing your helmet has to do with the terms of your insurance policy. Does your policy require you to wear a helmet? If so, then your insurance company may not cover you for the accident. The other driver's insurance company will try and deflect responsibility by saying that had you worn your helmet, you either wouldn't have been hurt or not as badly as claimed. The helmet issue is purely a diversion and meant to intimidate you from pursuing a claim. I have a lot of medical bills and will be in treatment for a long time. How long will my case take? A good law firm understands that time is important to you. The amount of time is hard to determine. It depends on several factors. 1. How much is the insurance policy of the at-fault driver? 2. What are your injuries? And 3. How long will it take to get your medical records from the treatment you have had so far? If the value of your injuries exceed the amount of the at-fault driver's insurance policy, then your case needs to be resolved fairly quickly. Every day that passes that your case does not settle costs you money. You need to understand that there is a fixed amount of money that you can get from the at-fault driver. That amount is determined by how much his or her policy is. So, if the at-fault driver only has a $50,000 policy, but the value of your injuries are worth $100,000, then the medical bills you incur each day will take away from any final settlement that is reached. The takeaway will come from your portion of the proceeds. That is why, when having a lawyer who understands the importance of time is critical. Settling your case early for the policy limits of the at-fault driver allows you to retain more of the settlement proceeds for yourself. The value of your injuries will determine how quickly your case can be resolved. Occasionally, this may require getting an outside medical opinion to tell us what the full extent of your injuries are. If I was at fault for the accident, is there any chance I still have a case? Well, that depends. Accident reports are not admissible as evidence in civil cases. The facts that give rise to the police citing you for the accident will come out in court, and the other driver will use that to his advantage. But in Florida, there is this thing called comparative negligence, meaning if the other driver shares any responsibility for the accident, then you have a case. These cases are highly contested and often require experts to prove your version of how the accident occurred. Based on the complexity of these types of cases, it is important to contact a lawyer immediately after the accident so you can begin evaluating your case. These are just a few of the questions about personal injury law we answer every day here at Alliance Legal Group. If you need clarification on any of this, please don't hesitate to contact us. You can reach us at 877-560-4440 or visit our website at alliancelegalgroup.com. All of our initial consultations are completely free. Remember, Alliance Legal Group will always be there for you. I'm Joe Benson. Have a great day.